I think there's a number of people joining, so we're just going to wait till, give it one more minute and then we will begin. Just for everyone who's just joined, I was just saying that we're just going to give it a minute, just as a number of people still seem to be entering, and then we will begin the webinar. So thank you very much for joining and hanging on with us. Excellent. Good afternoon, everyone, and welcome to this Francis Taylor Building Public Law webinar. The topic we'll be covering today is Judicial Review Costs and Procedure. My name is Stephanie Bruce-Smith, and I'm a barrister here at Francis Taylor Building. I'm one of the members of the FTB's Public Law Practice Group. I'll be chairing today's webinar. So delighted to see so many people logging in. We hope that there will be time for questions at the end of the presentations, and we'll be taking questions via the Q&A function, which you should be able to access at the bottom of the screen. Please do feel free to type in questions as we go along, and we'll aim to answer them in a block at the end of the session. We will be ending at 2 o'clock sharp, even if we haven't got through all the questions. But if you have any burning questions, please do feel free to email us afterwards, and we'll try to get back to you with any questions that have been submitted via the Q&A function, but we haven't had a chance to answer. The speakers today will be using PowerPoint presentations, and you will receive copies of these slides after today, and we'll also be recording today's webinar and publishing it later on Francis Taylor Building's YouTube channel. So as I just mentioned there, the webinar aims to give an update on judicial review procedure and costs. And we'll have two speakers. So the first speaker is Armin Solimani, who is going to give an update on judicial review procedure, covering topics such as alternative remedies, promptness, standing, and the duty of candor. We will then hear from Michael Feeney, who will be focusing on costs in judicial review, and in particular on recent developments in ARVIS costs. I'll introduce the two speakers as they just before each of their presentations. So first up, we will have Armin Solimani. Armin joined Chambers last year following successful completion of pupillage at FTB. He is regularly instructed in the High Court as sole and junior counsel, and is currently instructed on a number of high-profile judicial reviews. Before coming to the bar, Armin served as the judicial assistant to the current senior president of tribunal, Sir Keith Lindblom, in the Court of Appeal, assisting on some of the most significant appellate public law cases of recent years. So Armin, thank you when you're ready.
Thank you very much, Stephanie. Let me just share my screen. There, I hope that's working. So yes, there are the speakers, and this is the update on procedure. Thanks so much for joining us. As Stephanie said, it's a real pleasure to have so many of you. So much timer. I'm going to be speaking about judicial review procedure. Primarily, it's about giving you an update on the events in procedure over the past year or so. There have been some significant changes, some significant clarifications. But I'll also just discuss briefly as well those procedural elements, give you a bit of a primer on them to help give context. So in terms of what's in store today, first it's brief introduction to JR procedures and overview. Then it's choice to use judicial review and alternative remedies. We'll be dealing with promptness and delay, limitation, timing, that sort of thing. Then standing, which is whether someone actually has a right to bring a claim. Amenability to judicial review, which is whether a particular decision is actually a decision that can be judicially reviewed. Is it really a decision of a public nature? And then finally, we'll come to the duty of candor and redactions. Most of those, apart from the duty of candor, are what we call procedural bars in judicial review. They are essentially, they act the way limitation acts. Essentially, it's a roadblock to a claim. So if those procedural bars exist in your claim, no matter how good your claim is, even if it's very strong, even if it's quite clear the government has behaved unlawfully, if the defendant authority can successfully establish one of those procedural bars, there's a good chance your entire claim may fall apart and may not succeed. So they're really important to understand. So they say here it's multifaceted, nuanced, and critically important. It is a tricky area of law. The reason it's tricky is because judicial review is broadly discretionary. So a lot of these procedural bars arise from discretions. They arise from the case law, from principles, from jurisprudence. There are identifiable tests that you can apply, but the tests are pretty general, pretty broad in scope, and they apply across infinitely varied public law claims and public law challenges. So it can often be quite hard to know whether a procedural bar applies or does not apply. Because they're so important, because they have the capacity to extinguish even a very robust claim, it is critically important to not only understand what these procedural bars are, but to think about them carefully. Whether you're a claimant, whether you're a defendant, formulating a claim, responding to a claim, first thing you should do, first thing I do, is think about the procedural bars, think about what might be argued. There is nothing more frustrating for a claimant than to put together a thoroughly researched, thought out, carefully articulated claim to find actually you have an adequate alternative remedy, and so you're barred from actually bringing the judicial review. Nothing more satisfying for a defendant to receive a very thoughtful, carefully articulated claim and just say, sorry, you're out of time, go away. So they're very important and important to get right. So the first one we'll deal with is choice to use judicial review and alternative remedies. Now, many of you will have heard the phrase, the principle, judicial review is a remedy of last resort. It is truly a remedy of last resort. It should be the port of call you come to when you've exercised every other kind of statutory appeal mechanism. Now, for many, many kinds of government decision makings, for local authorities, for national government, for quongos, there will be statutory bases, there will be statutory rights of appeal for their decisions. So a statute that gives the decision-making power to that authority will often say, if someone has a problem with this decision, they can appeal via this mechanism. And the idea of a remedy of last resort is that you use those mechanisms first. And if you don't do that, if you bring a judicial review claim anyway, then you may find your claim is barred by this principle. Now, the update is a significant case that's before the Supreme Court. Mikalinen's application for judicial review. Ms. Mikalinen, she lived near a nearby dump, and she wanted to challenge the public body that was responsible for controlling and regulating that nearby dump in order to prevent the emission of toxic gases. Now, the dump itself was operated by a private waste management company, but it was regulated by a public body. What Ms. Mikalinen was saying was basically, the public body that regulates the operation of this dump isn't doing its job, because if they were doing their job, there wouldn't be these toxic emissions. She went to a court of appeal eventually, and they determined she had an adequate alternative remedy, so she couldn't get judicial review. They said she could seek a private prosecution, or she could make a tortious nuisance claim against a site owner, or she could complain to a statutory ombudsman. And the Court of Appeal's view was essentially those were adequate alternative remedies, because in practical terms, they would achieve the same thing that she wanted to achieve by means of judicial review. In other words, those other remedies would enable her to control the emission of toxic gases. That's what she wanted after all, so she had an adequate alternative remedy. Supreme Court disagreed with the Court of Appeal, and they essentially said two things that run together. One was that litigants in civil actions are entitled to choose their preferred remedy. Now, in private law, you often have claims that may arise in tort, claims that may arise in contract for the same kinds of breaches, same kind of injury, and you're obviously entitled to choose which procedure you want to use. And the court emphasized that people are entitled to choose a remedy that they prefer, because certain remedies, judicial review versus a private law claim and nuisance, come with different risks, different procedures, different costs for litigation. people are entitled to make a choice. But in terms of the adequate alternative remedy doctrine, what they said was that although it is true that these other remedies would achieve the practical goal, which is to prevent toxic emissions, in reality, what Ms. Michelinen was trying to achieve by means of her judicial review claim was actually to make the public body comply with its legal duties. Because in her view, she was saying they were in breach of their obligations under the statute. And that particular outcome she was seeking could not be achieved by private remedy. So suing the private operator of the dump and nuisance might control the emissions, but it would not force the public body to actually regulate the dump properly. And it would not confirm that the public body had been in breach of public duties. So there was that difference there. And I think the principle, and so essentially Supreme Court said she didn't in fact have an adequate alternative remedy under the doctrine, and so her judicial review claim could proceed. Now, the principle I take from that is essentially that a true adequate alternative remedy is not just another legal means to achieve the same practical outcome that you're seeking by means of judicial review. It has to be a legal means that also ensures that the public body you're challenging actually complies with its legal duties. And that kind of seems to limit the scope quite a lot more to just requiring that you go through statutory appeals processes where those exist. And it's not just about achieving the same practical outcome. Next procedural point is standing. Now, standing is basically about whether someone actually has a right to bring a judicial review claim. So again, you might have a very good case that the government has behaved unlawfully, you might have detected some clear unlawfulness, but if you're completely unrelated to that public law error, if the government's bad decision-making really has no effect on you or your interests, then you probably don't have standing, and the court will not hear your claim. And for decades, there was a liberalizing approach to this. The courts were more and more inclined to just say, you know, there's clearly a public law error here, so we might as well give this person standing. There's been a little bit of a sharper turn towards a more conservative approach, particularly since the Good Law Project case a couple of years ago, where you had this pressure group launching judicial review over things as wide-ranging as tax legislation, things like public procurement. And the court said, you know, that started to put a bit of a stop to the liberalizing trend. Now, the test in statute is that an applicant has to have a sufficient interest in the matters to which the application relates, which is a pretty broad test. And the important thing to note is the test is interest-based, not rights-based. So it's not like in private law where if you want to bring a contract law claim for an injury, you have to prove that you had a contractual relationship with someone, your rights have been infringed. This situation, your legal rights don't need to be affected. What matters is your interests have been affected. So things like your financial interests, your amenity, your quality of life, what have you. You just need to show that you've been affected materially by the public decision you're challenging. Now, Redrow was a really interesting case where essentially it arose, the context arises from the Grenfell Towers and essentially the cladding crisis that came after. And the government had this problem where you had all these towers with defective cladding, but no one knew who to sue for that and who to get to pay for remediation. So they created the Building Safety Fund. Well, the Building Safety Fund basically allows people to do, it's like a pool of money from the government where the managers of towers with defective cladding claim money from the Building Safety Fund so they can immediately repair the defective cladding and avoid the fire risk. And then the government or the management company can then sue or pursue the developer of the building who put the defective cladding there to recoup that money. Now, what happened here was there's a government decision to give the operator of a building, the manager of a building, £30 million in order to repair defective cladding. And the developer of that building, who would presumably, in light of that, be pursued for the £30 million that's been borrowed from the fund, decided to apply for judicial review and challenge the decision of the government to disperse that money. And what the government said was essentially, they're strangers to the claim. You know, the decision was about giving money to a building manager so that they could repair defective cladding. It didn't involve the developer who put the cladding there. That might come later. But the Court of Appeal disagreed. What they said was that when you make a disbursement from the Building Safety Fund, you're making a prima facie statement that the developer is liable for these costs. Eventually, they're liable for defective cladding. And that materially affects the interests of the developer because they're beginning to be on the hook for £30 million of costs. So clearly there's an affected interest, and clearly they did have standing. There's another recent case, Rights Community Action. Just briefly say that a useful principle that, or useful analysis from Justice Levin was that, in relation to Good Law Project, was that you shouldn't take the doctrines from the Good Law Project too far. Essentially, strategic claimants with a genuine issue and a relevant stake do continue to have standing. Standing really depends on the entire factual context and merits of the case. And it's important to note that whilst there's been some jurisprudence suggesting to the contrary, the fact that another challenger would be better placed to bring a claim is not sufficient basis for saying someone does not have standing. So ultimately, the standing test, it's a broad one, a flexible one. You have to look at all the facts of the case and look at material interest being affected. But it still remains pretty liberal and pretty broad. Next topic is promptness and delay. This is about timing and the limitation effect of timing. Now, we'll all be familiar with the deadline for judicial review claim, which is promptly and in any event not later than 3 months after the grounds to make the claim first arose. 2 points to say about that. One is people, I think, instinctively sometimes think of the deadline for JR claims as being 3 months. It's not correct. The deadline is promptly. 3 months is just a backstop. And you could make a judicial review claim quite plausibly, where you make it within the 3-month time limit, but the court says, actually, this hasn't been prompt. You could have issued this a lot more quickly, and therefore you haven't met the deadline, and you're barred from bringing this claim, and that does happen. And the policy behind this, the reason for these limitation requirements for the very tight timeline, and is of course even tighter in planning cases with a 6-week deadline, is essentially the government needs to have finality, needs to be able to make decisions and move on with things. It can't make public decisions and risk for a long time afterwards there being a risk that someone's going to come along, make a successful JR, and then unwind a big decision. So coming back to Redrow, in fact, this case quite usefully dealt with 2 really interesting public law principles. Essentially what happened in Redrow was that they filed the claim within the 3-month limit, but it was argued that they filed the claim insufficiently promptly. Now, what had happened was Redrow, the claimant, the developer who was suing the government, they'd basically been in communication with the government about their proposed claim. The government had said to them, okay, we'll respond to your letter in 2 weeks' time. This wasn't a PAP letter, by the way. It's just sort of an initial communication as part of the PAP. Government said they provided a substantive response. They never did. The developer waited for a little while. That response never came through. And then they issued the formal PAP letter. And the government said, we need more time. We can't respond within the 2-week deadline required by PAP, the PAP rules. And essentially, a lot of the delay was caused by the defending government, essentially delaying things, not responding in time, taking too much time. And so the court, unsurprisingly, said, even if this claim could have been made sooner, even though there is some prejudice because the time it's taken to make the claim potentially means that quite a lot of money has already been spent and some building work's already started, although I did say that probably would have happened anyway. Despite that, the claim is considered to be prompt because it's the defendant's fault. So for local authorities, for government decision makers, it's important when you're engaging in these kinds of communications to try and make sure you keep to deadlines, try and make sure you are actively communicating, because if you're not, that could defeat a promptness challenge. The court can also extend time, and that's pretty exceptional. One case that's occurred recently is ZRR, which is a case about the providing of suitable accommodation under a local authority's housing duties. And the claim was made after 4 months, so obviously delayed and beyond the backstop. But part of the problem was that it was unclear, both to the claimant and the defendant local authority, how the Housing Act actually applied to her claim. When you looked at the sort of pre-action correspondence, when you looked at the way the particulars of claim were filed and the responses given from the local authority, it's clear that people weren't actually sure how the Housing Act actually applied to her situation and when the relevant decision actually happens. There's a lot of lack of clarity on both sides due to the nature of the statutory framework there. And in that circumstance, the judge said, fair enough. It is past the deadline, but we couldn't have expected her to really make a claim sooner because it just wasn't clear what the legal position was. That was very hard to figure out. So there is scope to extend time. And you should be careful to note that, if you're a defendant decision maker and you think the 3-month deadline has passed, almost every case, you're right, a claim can't be brought, but there can be some circumstances where time will be extended. So do consider that and think about whether there are relevant factors which might make the court extend time and your decision no longer is insulated from the limitation protection. Next topic is amenability judicial review. Now, judicial review only applies to a body exercising public functions. And a lot of and that's essentially because judicial review quite obviously is about the rule of law in a democratic society. It's not about making private businesses behave themselves. It's not about making private individuals behave transparently or accountably with each other. It arises as a remedy because we live in a democratic society. We want to make sure our government and public authorities that we pay for with taxes and we vote for behave in a way which is appropriate in that kind of society. So accountably, transparently, in line with public law principles. So it only applies to bodies exercising public functions. And there's essentially two ways you can identify that, whether a body is amenable to judicial review. The first is if they're exercising powers under a statute. So if a statute gives a body a decision-making power and a decision is made under that statutory provision, that will be amenable to judicial review. It's a public power being exercised. But then you also get functions which kind of seem public, but kind of aren't. And it is very tricky to identify which functions are actually public and which aren't. It says the test is multifactorial and falls to be assessed on a case-by-case basis. There's no single test of universal application. Indeed, in the case law, the approaches are really just fact-specific. I recently was involved in a matter, without going into too much detail, involving a utility provider providing a utility nationally that used to be a function of the government but is now being privatized. And the question was whether their operations had a public quality to them. And you might say, on the one hand, well, they're providing services that are integral to the nation's survival in a way. They're providing services that the government used to provide as a government body. But on the other hand, you would think, well, they're a private corporation. The services they provide are made under private contracts and not by statutory power. My view was that they were acting as a private body, and so their decisions weren't amenable to judicial review. So a recent case, Shashikant, dealt with this, and essentially what had happened was there was this GP, he was the claimant, and he'd formed a contract with the local clinical commissioning group, which is essentially the sort of state body which gives out financial contracts to provide medical services in the local area. So he's contracting with them that they would pay him and he'd provide medical services. They had a dispute under the contract, and under the contract's provisions, you can refer that dispute to the Secretary of State. Now, the important thing to note is that you can arrange these contracts with the clinical commissioning group privately, as this GP did, or you can essentially do it under statutory powers. So clinical commissioning group can sort of form more public law natured contracts with people. This was a private contract. And so when he judicially reviewed the decision of the adjudicator who ruled against him on the contractual dispute, the High Court said initially that actually this adjudicator was not exercising public functions. The relationship was a private law one. The dispute was really about a dispute over contract, and all the adjudicator was doing was resolving a private law contractual dispute. The Court of Appeal disagreed, and the reason they disagreed was that even though, in a sense, the power of the adjudicator to get involved arises from a provision of a private contract, the actual power that the adjudicator was exercising, the authority to resolve that dispute, was one he got from a statutory framework. It was the statute that gave him the legal authority to resolve those kinds of contracts between clinical care groups and local primary medical providers. So for that reason, when he was exercising that power, when he was adjudicating that dispute, he was exercising a statutory decision-making power, and therefore it was amenable to judicial review. And finally, just touching on the duty of candor. Duty of candor isn't a procedural bar, of course, but it is extremely important. You'll all know it's the obligation on public bodies and indeed claimants in judicial review proceedings to have all your cards face up on the table, to be honest up front about the facts. And the reason we have the duty of candor and the reason why it's so important is because judicial review, unlike a lot of civil litigation, does not have formal disclosure requirements. There was a case in 2024, widely reported, the case of IAB. And essentially what had happened, relevant point in that case, was that for the duty of candor, was that the government in the evidence had been submitting, so for example, reams of emails, internal emails between junior civil servants. What it had been doing when it was submitting them to court was, as a matter of practice, as routine, redacting the names of the civil servants, redacting their email addresses, and then providing them. And the court firmly criticized the government for doing that. The government said it was irrelevant, and the court said that doesn't matter. The reason it's important, what the court essentially said was that just because something's irrelevant does not mean you're allowed to redact it. You need to, the duty of candor requires you well, you're not entitled to redact things just because they're irrelevant under the duty of candor. Now, the Administrative Court Guide, also published last year, was then updated to reflect that, and now advises decision makers that it's inappropriate to redact details, such as text which explains the provenance and context of a document, such as the name of the sender, recipients, or copy recipients of a document. Redaction should be limited to information which is both confidential and irrelevant, or is legally privileged, or is subject to statutory restriction on disclosure, or attracts public interest immunity. One important point to note is that if you're planning to redact material, or if you do redact material, you need to explain the reason when you're disclosing that. Now, you don't need to go into a huge amount of detail, but a single word description isn't enough. You can't just say it's legally privileged. You need to give some kind of explanation as to why things have been redacted. I generally advise clients, well, governmental clients primarily, to err on the side of caution when it comes to duty of candor. It is such an important duty. I remember when I was being supervised by Richard Honey during my pupillage, he said the thing that most keeps him up at night is the duty of candor, because it applies to barristers, it applies to solicitors, it applies to all lawyers involved. We all have to be satisfied that we fulfilled our duty of candor to the court. So generally best to err on the side of caution and disclose where you can. There was also a recent case. I'll just briefly say the principle is if you're sending confidential material to the court, you should copy in other parties. If you're not giving them the actual material, you should explain why. And that pretty much covers everything for me for procedure. So I will hand back to Stephanie.
Thank you, Armin. So next we have Michael Feeney. So Michael is building a strong practice across all of Chamber's practice areas, particularly in public law. He has acted successfully for both claimants and defendants in multiple judicial review claims, covering a wide range of topics in public law, including planning, environmental law, and licensing. He is also instructed as sole and junior counsel in several ongoing cases, including one that is due to be heard shortly in the Supreme Court. And just before I hand fully over to Michael, just to remind everyone and to those who might have joined a bit later that if you have any questions either on the previous presentation or on Michael's presentation, please pop them in the Q&A function and we'll seek to answer them at the end. Thank you. So, Michael.
Thanks, Stephanie. I will just try and share my screen, which I think I've managed to do successfully. So good afternoon, everyone. When I was planning on doing this talk, initially I was going to do a general talk about costs in judicial review. I think it's an interesting topic, and although most of the time it's relatively simple to see that whoever wins should get their costs, there can in judicial review be some complications. In particular, sometimes it can be difficult to tell who the winner actually is if a claimant hasn't got everything that they've asked for, or if the form of relief doesn't exactly replicate what the claimant asked for in the claim form. And also sometimes when a claim has been rendered academic by a subsequent decision. But I'm afraid I'm not actually going to talk about costs and judicial review because, in general, because 2 weeks ago there was a very interesting and I think potentially significant Court of Appeal decision about Aarhus costs called HM Treasury and Global Feedback. So in this talk, instead, I'm going to focus on that Court of Appeal decision. And as ever, if you are interested in costs and judicial review more generally, then I'd recommend, as a starting point, looking at the Administrative Court Guide, which always has very useful, relevant information. So turning then to an overview of the Aarhus cost regime, this is obviously, many of you might know this already, and it's really just a quick run through of the relevant provisions in the CPR. So first, CPR Rule 46.24 defines what an Aarhus Convention claim is. Essentially, it's a judicial review claim or review under statute brought by a member of the public, which challenges the legality of any decision that falls within the scope of Article 9. So the case I'm going to be discussing today, HM Treasury and Global Feedback, really focuses on what the scope of Article 9 is, and therefore whether a claim is or is not an Aarhus claim. Rule 4625 says that a claimant has to state in the claim form that the claim is an Aarhus claim, and then also file and serve a schedule of financial resources in order for the claim to qualify. And the third point, Rule 26, is that if a claim is an Aarhus claim, then if the claimant is an individual, they can't be ordered to pay more than £5,000 in costs to the other side, or £10,000 if they're an organization. And if Aarhus cost capping applies, then on the other end, the defendant cannot be ordered to pay more than £35,000. Those are sort of the starting points, as it were, because in Rule 27, the defendant can apply to vary the cost cap if doing so would not render the claim prohibitively expensive. Prohibitively expensive is the test in the relevant rule. So, for example, if the claimant in their schedule of financial resources discloses that they have £200,000 saved up, you might apply to vary the cost cap and say, well, they could afford to pay more than £5,000. It wouldn't be prohibitively expensive. So you apply to vary the cost cap upwards to, for example, £10,000 or £15,000. And then finally, Rule 28, in addition to applying to vary the cost cap, the defendant can also deny that the claim is an Aarhus claim altogether. And if the defendant does that in their acknowledgement of service, then the court is required to determine that issue as soon as possible. So that's a brief run through the regime in general. Turning then to this Court of Appeal decision, judgment of Lord Justice Holgate that came out a couple of weeks ago, HM Treasury and Global Feedback. The key issue at the central of the case was the meaning of the phrase in Article 9.3 of the Aarhus Convention, which contravened provisions of its national law relating to the environment. So really what was at the heart of this case is, what does that mean, national law relating to the environment? And very briefly, the factual background to the claim was that it was a challenge to a decision to make regulations which gave effect to tariff preferences on Australian imports. The decision was taken under the Taxation Cross-Border Trade Act 2018, which isn't a piece of legislation that directly seeks to protect or regulate the environment directly. However, the claimant was concerned that the decision would have adverse environmental effects. In summary, the claimant was concerned that this decision would increase carbon emissions from beef, both from increasing the import of beef from Australia and also because of the differing regulations that apply in Australia compared to the UK. So for those reasons, that was, as it were, the motivation for the claimant bringing the claim. And the claim was brought on 3 grounds, which I've set out on the slide. These in detail for the purposes of the talk today. What's important to note is that the first 2 grounds essentially are allegations that there were breach of public law principles, that the Secretary of State defendant either acted irrationally and or failed to take into consideration material considerations when assessing potential carbon leakage, i.e. increased carbon emissions. So grounds 1 and 2 were alleged breaches of public law principles, and ground 3 was a failure to comply with Section 28 of the 2018 Act. Failures have regard to the United Nations Framework Convention on Climate Change and also the Paris Agreement. So with that factual background, at first instance, the High Court, Mrs. Justice Lang, decided the Secretary of State submitted that this was not an Aarhus claim, and the High Court, Mrs. Justice Lang, decided that it was an Aarhus claim. So the Secretary of State appealed, which led to the Court of Appeal judgments of Lord Justice Holgate. So turning then to the judgment itself, the first important point was Lord Justice Holgate found that relating to in Article 9.3 is a strong, not a loose connector. So relating to can appear in many different forms of legislation, many pieces of legislation, and Lord Justice Holgate, based on a reading of Article 9 as a whole, found in this case that it was a strong connection. And so it wasn't enough to mean some tangential or indirect connection with the environment. And then paragraph 92 of the judgment, which I've set out on the slide, is really the nub of the reasoning and the nub of the judgment. I won't read out the quotation on the slide, and the slides will be sent to you after the talks. But really what this means, paragraph 92, is that the focus has to be on whether the law itself relates to the environment, not whether the decision or the claim would have environmental effects. So the focus has to be quite narrowly on the provision of law that it is alleged has been breached, rather than any potential environmental connections or effects. In reaching this conclusion, Lord Justice Holgate had to consider a number of previous decisions which had considered Aarhus, some of which were frankly a little bit difficult to reconcile with his reasoning. I'm not going to go through all of the previous cases. I'm going to focus just on the two that I think are the most significant and important. The first one is a case called Venn, which is also a Court of Appeal judgment from 2015. Very briefly, Venn was a planning case. It was a challenge to a grant of planning permission by an inspector for the erection of a single dwelling. And since 2015, Venn has become kind of the standard case that is cited all the time by claimants when asserting that their claim is an Aarhus claim. And that's because paragraph 11 of Venn has this, if you're a claimant, very useful quotation. Under Aarhus, the definition of environmental is arguably broad enough to catch most, if not all, planning matters. So at first glance, that doesn't necessarily seem compatible with Lord Justice Holgate's reasoning, but in the course of his judgment, Lord Justice Holgate explained how his judgment was compatible with Venn. And essentially, what he said is that Parliament had chosen to implement much of the UK's environmental protection through planning, but that a lot of that protection was not included within legislation itself, but actually within policy. So local development plans, national planning policy framework being the most obvious examples. Section 70 of the Town and Country Planning Act and Section 38(6) of the Planning Compulsory Purchase Act require regard to be had to the development plan and other material considerations, which will include those policies that are intended to protect and regulate the environment. And so the finding in Venn, according to Lord Justice Holgate, is that it's this combination of law and policy that comprises a national law relating to the environment. And so if I go to the next slide, we'll see the conclusion really in paragraph 105, saying that Section 70 is not itself a legal provision relating to the environment, and that a claim doesn't fall within the scope of Article 9.3 unless the material consideration left out of account was a policy for the protection or regulation of the environment. And as you see, the final sentence there is referring to Lord Justice Sullivan's judgment in Venn. So Lord Justice Holgate explaining what is really meant by paragraph 11. And then the next case to discuss, next and final case to discuss briefly, Friends of the Earth and Secretary of State. This case concerned a challenge to provide finance for offshore gas facilities in Mozambique. And Mr. Justice Thornton, the High Court, originally found that this was an Aarhus claim because essentially the circumstances of the case were analogous to Venn. There was policy and guidance on funding decisions, so the requirement to have regard to that policy and guidance meant that this was national law relating to the environment, and it was an Aarhus claim. Lord Justice Holgate in HM Treasury has held that this was wrongly decided in paragraph 150 of his judgment. I've set out the quote there on the slide, but essentially the reasoning is that in this case, the defendants were acting under a statutory regime which was not concerned with the protection or regulation of the environment, and that the claim really, in essence, was a failure to comply with public law principles. Which brings me on to the next slide. And this is perhaps one of the most important points in the entire judgment, that public law principles in and of themselves don't form part of the law relating to the environment. Again, I've set out the quote there, paragraph 132, but the judgment of the Court of Appeal is that public law principles are part of our constitutional framework, and they're not in and of themselves environmental law. And so a breach of public law principles in isolation will be insufficient to bring a claim within the scope of Aarhus. So perhaps unsurprisingly, given what I've said about the judgment so far, the overall decision in this case was that the purpose of the 2018 Act was not to protect or regulate the environment, and that as a result, there'd been no alleged breach or provision of environmental law. So it wasn't an Aarhus claim, even if the claim did have some effect on or connection with the environment, because the 2018 Act itself, the purpose was not to protect or regulate the environment. So that's been a relatively deep dive into the judgment, which, if you have time and or interest, is worth reading in its entirety, because it's a thorough, interesting judgment, which includes consideration of a number of important decisions. But in terms of what this all means and for takeaways, I thought I'd separate into implications for claimants and implications for defendants. So first, for claimants, what this means really, first, I think it means that claimants, perhaps more than they have done in the past, will have to make it clear what provision of law relating to the environment they're saying has been breached. There can be a tendency sometimes for claimants just to quote paragraph 11 of Venn, and then sort of it's just kind of waved through and no one really thinks about it. I think following this judgment, claimants will have to be more precise about what provision of national law relating to the environment they are saying has been breached in this case. And that's important, obviously. That's important, obviously, to establish that it is an Aarhus claim. I think it's also important just to avoid any potential pushback. The risk is that if you don't make that clear at the outset and up front, then in light of this judgment, defendants might be more interested in pushing back, and it might create some sort of satellite litigation that you might not have to deal with otherwise. And so the best way to avoid that issue arising is just to deal with it straightforwardly and immediately in the statement of facts and grounds. The second point, implications for claimants, of course, each case is going to be highly fact specific. So to some extent, it's difficult to talk in generalities. My own view is that most planning claims are likely to remain Aarhus claims. HM Treasury confirms that the reasoning in Venn is correct. And in most planning judicial review claims, it won't be too difficult to find a breach of national law relating to the environment because there's recognition, acceptance that the purpose of the planning regime as a whole is to protect and regulate the environment. It's important to remember that HM Treasury was a case about tariffs and trade. It wasn't a case about planning. And so the decision in HM Treasury is likely to be more relevant for areas other than planning, such as trade, tariffs, financing decisions, those sorts of areas. So although I think it is an interesting and potentially significant case, in general, most planning claims are likely to remain Aarhus claims. But that brings me to the third point on the slide, that there will be difficulties potentially in other areas. I've just flagged a couple on the slide. One potentially would be human rights climate change litigation. Of course, that litigation has clear and obvious environmental effects, but is the Human Rights Act legislation whose purpose is to protect or regulate the environment? It's not clear that it is. And similarly, compulsory purchase. There's a tendency now to consider that compulsory purchase claims are likely to be Aarhus claims because ultimately they relate to what's done with land, what's done with the environment. But again, following this judgment, I think people will need to think a bit more carefully about, is the purpose of compulsory purchase legislation to protect or regulate the environment? Because we now have a strong statement that that's really what the focus needs to be on. And then turning then to implications for defendants, well, I think the first obvious point is really to consider whether the claim genuinely is an Aarhus claim. What provision of national law relating to the environment is said to have been breached? Is there any provision of national law, or is it actually just public law principles, which it says have been infringed? And related to this point as well, it's important to consider each ground individually. So there might be a claim with 3 or 4 grounds, and maybe only one of them would fall within Aarhus and the other 3 or 4 wouldn't. And if that's the case, it's worth making the point that if you're able to knock out the one ground that does fall within Aarhus at the permission stage, then the rest of the claim potentially shouldn't benefit from any cost capping if the rest of the claim wouldn't fall within the scope of Aarhus. So considering whether the claim as a whole, but also more particularly whether each ground really falls within the scope, I think is an important exercise to undertake when you're the defendant. Just a slight warning I've put on the second slide, on the second point, is that if the defendant does contest whether the claim is an Aarhus claim and then they lose and the court finds that it is an Aarhus claim, then the defendant has to pay the claimant's costs. And that would hold even if the claimant ultimately was unsuccessful in the judicial review claim. The defendant would still have to pay the claimant's costs of deciding that discrete issue at the beginning. So there is a slight risk in contesting whether it's an Aarhus claim. So it's not something you want to do kind of automatically or unthinkingly, but it is something worth, I think, considering and perhaps considering in more detail following this judgment than has been done so far in practice. And then finally, this perhaps doesn't arise from the judgment, but I think is a point worth making. There is provision, as I said at the beginning, if you're a defendant, to apply to vary the cost cap. And while there is a potential risk in denying that a claim is an Aarhus claim overall, for the reasons given in the second bullet point on the slide, there's very little downside in applying to vary the cost cap upwards. If you're a defendant and looking at the schedule of financial resources, you think the claimant can afford to pay more, and you say the cost cap should be varied upwards to 10, 15, 20,000 pounds, well, you can say that in your acknowledgement of service. And then if the court disagrees with you, all that will happen is they won't vary the cost cap. That essentially is the end of it. So there's very little downside to applying to vary the cost cap. So it's always something worth considering. Of course, I wouldn't advise doing it unreasonably. If the schedule of financial resources says that the claimant has £2,000, there's no point applying to vary the cost cap. But in general, there's very little downside in making such an application, so is always, I think, worth considering when you're a defendant. So I think that's everything I had to say today about Aarhus and HM Treasury. So I'm going to stop sharing my screen.
Excellent, thank you. Sorry, thank you very much, Michael. So we've had a few questions in, so we're just going to start off with some of those. And again, please do send in more questions if they come to you. either from these questions or having reflected further on any of the talks that you've had today. So the first question is on privatisation, and there's an observation that privatisation seems to be an effective way of evading judicial review. And the question is whether there is any case law showing how the courts are showing what the courts approach when a government's act of privatising a public asset is challenged by way of judicial review. So I think it's whether there are any examples of judicial review challenges to the decision to privatise an asset. And maybe just if I could ask Armin if you'd like to answer that one, please.
Sure. So I wasn't able to find any successful JRs of decisions to privatize. I mean, the decision to privatize, I suppose, in principle, could be amenable to judicial review. So an actual Secretary of State's decision to start pursuing the privatization or the consultation that would be involved in the decision to privatize, all of those things could be JR'd. But the actual act of privatizing a utility, usually as done by primary legislation in Parliament, that, of course, couldn't be judicially reviewed. And in terms of the other element of the question, which is, the extent to which decision makers can sort of insulate themselves from JR challenges by subcontracting their powers or their services or functions to private bodies. In principle, you can and often are entirely able to judicial review contracted out decision making, because the question is whether a decision is being made under statutory power or whether the decision maker challenging is exercising a public function. It's entirely possible for a state body to contract out their powers in a way that means the private operator will be exercising public functions. So, for example, if the government gave a contract to a third party to make decisions about people's welfare entitlement, that would essentially be public decision making, and you could judicially review those decisions, even though it's a private company. But by contrast, if the government subcontracts out the housing of homeless people to a bed and breakfast, the fact that bed and breakfast is providing the housing doesn't make them a public body or mean their functions are public in nature. They're just providing a private service. So there's that kind of dichotomy there.
Okay, thank you. And just one further question then on duty of candour before moving on to some of the questions that have come in on costs. So there's a question in relation to redactions that have been taking place for GDPR purposes, and whether in such circumstances a local authority, if certain redactions have been made for that, would they have to go through each one of those and check whether the reasons for them, if they've been told that certain names have been redacted for GDPR purposes? And Armin, if maybe you could answer that one as well, please.
Absolutely. I mean, it's with duty of candor, it's so fact specific. It's very hard to give a clear answer without knowing all of the facts, and I won't try to give one. But I'd say in general, the rules are in the administrative court guide. I think the applicable one would probably be whether the information is confidential and irrelevant. But a few things I would say. I mean, one is that at the PAP stage, very early in litigation, the duty of candor applies less strictly at that point. And the reason for that is so the local authorities don't have to disclose reams and reams of documents for a claim that may never come about or may not have any merit. The further along you go in the JR process, the more demanding the duty becomes, quite naturally. I think just saying for GDPR purposes, we're not giving the names may not be enough. It may well be at the PAP stage. I don't know without the facts in front of me, but I think it may be worth just checking whether the information is actually both confidential and irrelevant. And if you can say that, it's better to say that. Ideally, just saying GDPR probably wouldn't be enough. I mean, even in the civil servants case, they could have argued that the names, email addresses of the civil servants were protected by GDPR. They should be. But nevertheless, the government was obliged to give that information out.
Great. So turning to cost then, we've had a number of questions coming in to that. Maybe we could take two of them together if that's all right, Michael. So there's two questions that come in. One is kind of very shorter point is about someone asking on behalf of charity and saying that in some cases they bring a judicial review challenge supported by two other charities. And would that mean that the 10K, the £10,000 limit in Aarhus costs, would that be multiplied by 3 in those circumstances? So that's the first question. And then the second one that we have is asking about whether the requirement of national law relating to the environment could easily be defeated by Parliament not enacting any such environmental law, or just not acting at all, despite having obligations under international treaties to enact certain legislation.
Yeah, thanks, Stephanie. So the first one from Mark Weston, I think the short answer would be the starting point would be no. So the £10,000 limit would apply, but the schedule of financial resources which you're required to file, you have to say all the financial support you have received and are likely to receive. So you'd be required to disclose that information about other sources of financial aid. And then potentially, as I discussed during my talk, there might be an application to vary the cost cap upwards. But the starting point, as it were, would, I think, based on what you've said, be £10,000. And then the second question from Kokon Chen. Yes, I suppose Parliament could do that. It's hard to see how that would arise in a judicial review claim. So potentially that might be a breach of international law if there's an obligation under a treaty to implement some measure that then isn't implemented. But whether that would be part of domestic law would be quite a tricky question. And so I agree that it raises interesting questions potentially, but I think relatively unlikely to arise in a kind of domestic judicial review claim. And then I see there's one other. Were you going to move on, Stephanie?
Yeah, so I was just going to move on. There's one more on costs, and just to add in just maybe something else on that first question, I guess, in terms of the question of if it's whether Parliament could just not enact environmental legislation. There's already environmental legislation that's on the statute book, so obviously it'd still apply in that context as well, even if they decided not to enact anything new potentially.
I should have said maybe that some cases will actually, even after this judgment, some cases will be very obvious. Like if there's a breach of the environmental assessment regulations, that's kind of an obvious case, if I put it that way.
Right, so then just moving on to the second question, which is again on Aarhus costs cap. So Michael, if you could also turn to that, and I'll just so everyone can see it. The question is whether you've ever seen a court amenable to increasing the cost cap where a claimant is an SPV. So it's a presumably specific performance vehicle. I need to remember what SPV.
Special purpose vehicle?
Special purpose vehicle, that's the one. Set up specifically to bring a JR, and thus its accounts show limited resources, but they bring in donations and funding as and when required, and therefore show a continuing ability to bring and finance claims. So if you want to start off, and Michael, and if Armin, if you have anything else you want to add, or I might add anything at the end as well.
Yeah, it's an interesting question. I have to say I haven't personally had experience with that. Seeing the cost cap raised. As I said before, the schedule of financial resources is required to show financial support that has been received and is likely to be received. So that information should be disclosed as part of the schedule of financial resources. I suppose if there was some feeling that that requirement wasn't being complied with, then it could potentially form a ground for saying that actually it's not an Aarhus claim at all, because providing that schedule of resources is a requirement of it being an Aarhus claim. That would obviously be a pretty aggressive, robust approach, if I put it that way. But so I think I understand the problem that's been identified. So I think it would be possible to vary the cost cap, but frankly, I don't have personal experience of it in these particular circumstances.
Yeah, the only thing I thought I'd add is I don't have experience of an SPV. For example, I know residence groups, or I've been involved in cases where a group has been formed just purely for the purpose of legislation and for fundraising for that, and it hasn't been a problem as long as it's very clear, as Michael says, you set out precisely where you're expecting the resources to come from and how much you're expected to gain. And there's also another side of things to remember, is that you could be subject to requirement for security for costs if you have a SPV or another group which has limited resources to begin with. And I've been involved in a claim where at the same time as challenging the Archiv's cost cap, there's an application for security of costs made against the same group. So you can have that. That's normally more of an issue with those types of groups that are formed for the purposes of litigation. I don't know if there's anything else you wish to add, either Armin or Michael. I don't see any further questions coming up. I don't see any, nothing to add. Right, well, in that case, just leaves me to say thank you very much both to our speakers and to all of you for joining today. And as we said, the slides will be circulated after this webinar and the recording should be up in due course. So thank you very much and have a good afternoon, everyone.
Thank you. Bye, everyone.
Thanks, everyone.